We're taking a look at that. One idea may be that the coordinators, when they give out the appointments at the jail dockets, they only give you certain courts, right? That makes sense. So you're not going to 16 different courts, but we're mindful of that problem and we're looking at it. Okay, but for the time being, you represent that person, you go where they're set. And the problem to address your question about can I just put it on another court's docket, we're really trying to limit those dockets to those judges' cases and then all the new cases and emergent situations. So here's an example of an emergent situation. Let's say today's jail docket's a Court 1 jail docket, okay? Or let's say tomorrow's docket is a Court 1 jail docket, and you have a Court 15 case that you know the person's going to plead, and you don't want to wait a week to do that plea because you know if they plead tomorrow, they're going to get out of jail. Then you can let the Court 15 coordinator, so Laura Conte, know, hey, listen, we've made an agreement on a plea and we don't want to wait a week. Can we put it on Court 1's docket tomorrow? And then there is a procedure in place where that can be done. So if it means the person getting out of jail because of resolution of the case, that's an emergent situation where you can put them on the docket. Or if there's a bail issue, so the lawyer wants to address bail, that is a situation where you can put them on the docket. But I would encourage anybody, if you've got a client in jail and you are comfortable with them not being present, addressing any reset matters or bail matters at the bond docket with that judge, because that may get some business done that would keep you from having to go to the jail. Okay?
And when you do that for us, please submit that as out of court hours. I mean, we know that the jail and bond docket days are thin. So please, anything you do when you go over and see your client and try to work on the case or present some evidence to them, please don't forget to bill that. Dion. They're going to be at 9 o'clock. And let me just ask a huge favor. When we are doing those jail dockets, both male and female, please come to the jail first, because we only have 3 hours per docket with the male defendants, and they're trying to keep us to about 2.5 on the females. So the males is a little different because if I have the morning docket and it runs late, that pushes the afternoon people because they can't pull the prisoners. So please make every effort, and we are all cognizant of that. Please make every effort to come to the jail before you go to a bond docket. Dion, did you have another question?
No, I don't believe it.
Someone was touchy?
I'll do that. Yes,
I know
ma'am.
that wasn't one of my people.
Yes, ma'am.
Is there any effort to get us out of the basement at 701? I've had an asthma attack every time I go over there. And I've never had an attack while I did. I don't know what it is. I understand, we're trying to work it out, but is there any effort to try to get us out of that basement?
No, as a matter of fact, they made every effort they could to get us into that basement. So they were so worried, and it was taking so long to move the felony males that's why they put us there. I'd love to go back to 1307 actually, which is shocking. But yeah, we're stuck there.
Yes, ma'am. Are you talking to me? For a misdemeanor or felony? So you would. We had a lot of those situations during the flood where people were working terms in the morning and terms in the afternoon. I think that's probably decreased, but if you are in that situation where through the flood or even here recently you did a term and a term, then you will submit. As soon as you get the notice, go ahead and start submitting. You can submit it for 2 terms, yes. Yeah. And when I say term, I mean you're the attorney of the day and you're there to take on multiple new cases. You're not there on resets. Yeah.
John? On the felony side? Yes, I can tell you that the felony district court judges voted to raise the attorney fee payments. We are working now through Commissioner's Court. because they're the guys with the purse strings and the checkbook. So we are working. There are a number of steps that we have to take. I believe Judge Evans is making a presentation to them at their next meeting, although don't quote me on that. I know that she's been meeting with the budget office, so there's some things that are going on with that, but they're just, once we had our vote, then we had to jump through the hoops with the budget office. So we're trying to make it happen as quickly as we can. Understand it's not the greatest time. But it is very well deserved, because when we cut the pay back in 2008 or whatever, it was always with the intention to raise it back up once the economy got better, and it's just taken this long for it to happen. Okay, what else do you have?
I think that's it. You know, one thing I will say is this. We want to hear what impacted people have to say. So if the message you're getting is that the judges don't care what you have to say, or they're not meeting with people, or they're not listening to people, that is a false message that is being disseminated. Because we've had many, many conversations, Susan and I, through this whole storm, in text messages and emails and on the phone, late night on the phone with people, and in an effort to really get feedback on issues that were going to impact different stakeholders and really try to address those issues. So I say that only to encourage this. If you have an idea, we are receptive to good ideas. If you have a suggestion that is constructive on how we can do things differently, we are willing to listen. You know, we know that we can't anticipate every angle, you know, of how this is going to impact people. So I would encourage you to either do that through, if you're a member of HCCLA, you can do that through Tucker. You can do it yourself. You can stop by and talk to me, and I'll disseminate it to the appropriate people if I don't know the answer, or I'll try to get an answer. Or, and I know that Judge Brown is no longer the administrative judge of the district court, so it'll be Vanessa Velasquez, and I'm sure that she'd be receptive to that too. So it'd be great if we had some kind of suggestion box that people could just email, and maybe we'll do that. But in the interim, we are open to constructive ideas. Yes, sir.
And, let me just.
Oh, sorry.
Sorry. I just wanted to say that we, because we're all spread out so much, Judge Hart has agreed to sort of be an information conduit with HCCLA and Defense Bar to bring things to the judges. So please feel free. I mean, you can come by and see me. You can see Judge Velasquez. You can see him. But I know he's going to be working with HCCLA on that. I know not everybody belongs to HCCLA. So if you don't and you want to come by. The other thing I did want to mention, I had a lot of complaints early on about the visiting your client at the jail problem. And I've been working for the last 2 weeks, and to the point where I just flat out said to the sheriff, listen, here's what happens. Our lawyers show up to see their clients, and if they can get the deputy to turn around and pay attention and acknowledge that they're there, they might get to see their client. Because as one lawyer said, I can only do the low cough for so many times trying to get their attention. And I'm so glad that, and I'll get your question, I promise. So here's, after going up through the chain, you know, the command staff doesn't know what's going on. They think that when you guys show up, they're offering you like tea and cookies. So they understand now that seeing your clients is going to help resolve cases one way or another, and in a much more efficient manner than you being in a big room yelling at your client where there's 6 other defendants standing around. So they understand the need for you to see your client and to do it expeditiously. So not only have they told their folks working at the desk that they are to immediately respond to any requests, but if your client is not there, they are, because they're in the clinic or they're, you know, wherever, at GED class or whatever, they're supposed to let you know that right away so that you can come back another time. They have also positioned a deputy or a white shirt at every jail in the vestibule area who is responsible for taking lawyers back and forth up to see clients. So that is something new that they're doing. If you get there and there's not someone there, it's probably because they're taking somebody to a floor, but they are supposed to be able to escort you to the floor and that your client is called and pulled right away. So if that doesn't happen, please come see me, because it's really something, I mean, I've been on the warpath about this because it's just flat rude. And the reality is, for every hour that you sit over there, that's $85 the county's paying you. And as much as you'd rather be on Facebook for $85 an hour, I'd like for you to see your clients. So if that is an issue, and please spread the word about how this is supposed to work. There's supposed to be a deputy or a white shirt in the area when you come in the door, and you're supposed to be able to tell them, this is my client, this is where they're housed, and they're going to take you up there to do that. If that doesn't happen, please let me know, okay? Because that's really important. Back to your question. You know, I think, and I can only kind of speak for the way I do things, but much of my resets are incumbent on the lawyer telling me how long it's going to take to get something done. So I think that some of the problem may be there's not any communication with the court, whether it be the coordinator, and it may be you tell the coordinator and it falls on deaf ears. I completely get that. But please go to the judge and say, Judge, we're waiting on DNA. We know we're not going to get DNA for 2 months. Does my client really need to come back? Because there's no sense in resetting a case for 2 weeks when you're not going to get anything done. So, you know, please make the judge aware of what your issues are and why you need a longer reset. Because sometimes lawyers just want to see their clients. And so we don't know that. We don't know if your client is a college student and they're in College Station, lucky them, or if they're unfortunately in Austin. I have the yin and yang at my house, so I can say that. But you know, let us know that. So that's I think a lot of what has happened over the years is a lack of communication. If you let us know, we can make a better decision. So please do that. Don't, if it's a standard 2-week reset and nothing's going to happen, go to the judge and say, I need a longer reset. You know, some may tell you no, but I think for the most part, we're all looking to really try to work to have meaningful settings where something actually happens other than you coming in, signing a reset, and your client's missed a day of work or a day of school or a day away from their kids, whatever. So please don't be afraid to approach the judges. And, we have a lot of new judges on the felony side. And so they're not used to this. Please, and they're receptive to making change. So please, if there's an issue, go to the judge.
And just to add on to that, I would encourage people to ask the judge to waive your client's appearance, particularly if it's early on in the case. We had a reporter called me last week and said, why aren't the judges waiving the appearances? And I said, well, one, I don't know that they're not. And two, I think that if a lawyer approached a judge and gave a reasonable reason why an appearance should be waived, that a reasonable judge is going to grant that request. So I would encourage y'all to do that. If it's a case that you want to come back because you want to make sure that let's say the DAs comply with discovery, but you don't want your client to have to come back, go ahead and reset your case, but ask the judge if you can waive the appearance because you're just coming back to get, blood discovery or whatever it might be on a misdemeanor. So I would encourage y'all to do that and just pitch your reason for why, and that, even if you want to come back, but you don't want your client to come back, I would encourage you to ask to waive appearances. Just be sure you write it on the reset form.
And I don't know that is necessarily something that's going to work in felony. I think that what we would rather do is extend the time of the setting. We would rather say, well, why, if nothing's going to happen, if all you're going to do is pick up discovery, you guys need to do that outside of court. Get them to email it. I know the DA's office is working on emailing things, putting things on their portal. We'd rather have you and the client there so something can happen, whether it's getting the case set for trial or talking to a witness or doing whatever. The perspective is a longer setting to get everything done is better than you coming to court 3 times and your client's not there, because maybe there's a day where the state's going to make you a fabulous offer that your client would have taken, or there's something that needs to be discussed. So I think from our perspective, in general, we would rather give you a longer setting to make sure everything's getting done and then come back and let something meaningful happen, a motion or something like that, a trial setting.
I think the message is just ask. Yeah.
Right.
Anything else?
Judge Brown?
Come on.
I have a question. I'm not going to yell at you. I'm just going to make sure that we've got audio recording over here. Will you please expound upon the bail felony trials for the clients who are on bail? I'm just kind of curious about the logistics for when we're talking about court sharing. Is there a consensus about how much work can be done in a day, and what kinds of cases would be prioritized if there's some logistical problems with maybe only being able to work for 4 hours or something like that?
Well, since we're sharing courtrooms, I think what most of the judges are doing is they're working out a bail trial schedule amongst themselves. For example, I share with Catherine Cabanis. We're just setting our cases, and whatever works out, whatever gets dismissed, and then we're going to look and see who has the oldest bail case. Just kind of look for it, or there's a particular reason you've got an expert and they're only available that week. Different judges are handling it different ways. Some are taking a week at a time. So as far as how it's being prioritized, I cannot answer that question. I think we're kind of in a different world on bail cases. I think from the judge perspective, we've always felt the pressure to try that jail case. The guy's in jail. What if he's not guilty? We need to get a trial. So I think that now we have a little more freedom to, we're not fighting bail versus jail. We're not going to be trying jail cases. We're going to have 2 visiting judges over at Family Law trying those cases for us. So I think that your bail cases now, that we're going to be looking to resolve those cases and get those tried without that pressure of the jail breathing down our necks. But I would check with the judges in the courts where you have bail cases set for trial to find out how they're working it out. The other thing that's happened in the civil building is that the civil judges who are not sharing are giving us their court space as sort of a flex space. So if I'm in trial and Judge Cabanis has a bail case for trial, one of us can go somewhere else and try our case. So I don't know that we're going to be limited on space for bail cases. I think that we'll be able to get those. I think we're going to be more limited on the number of jurors that show up. So I think you're going to see a lot of bail cases getting tried in the next year since we're so limited on our jail cases, and we're just going to have to make